morning, the US Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts. So what does this mean for the criminal cases against Donald Trump?
Fight for Trump! Fight for Trump!
When he spoke to supporters on January the 6th, was he officially acting as the president or as the losing candidate?
We fight like hell, and if you don't fight like hell, you're not going to have a country anymore.
Hey guys, Adam is here. So what just happened? Let's be clear. The Supreme Court didn't seal Trump's fate. It handed him a shield. The immunity ruling throws a massive legal roadblock in front of any prosecutor trying to hold a president accountable for official acts. Lower courts and juries keep finding him liable, but the Supreme Court keeps handing him tools to delay, dodge, and outlast. Inevitable arrest is a political battle cry, not a legal reality. Hope and legal certainty are two very different things.
Donald Trump is facing criminal charges related to the January the 6th riot and attempting to overturn the election results. As his supporters stormed the Capitol building, they chanted, "Hang Mike Pence," angry with the vice president because he refused to block the certification of Joe Biden as president. Trump is also facing charges in the state of Georgia for trying to overturn the election result there. He phoned a local official and asked him to find more votes.
So, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state.
A court will have to rule on whether he was acting as president or not when he made that call.
In the case of Trump versus United States, decided in the summer heat of mid-2024, the Supreme Court delivered an opinion that fundamentally rewrote the relationship between the presidency and the criminal code. The holding was as sweeping as it was simple. The court declared that presidents possess absolute immunity from criminal prosecution for actions that fall within the scope of their core official duties. Furthermore, they possess presumptive immunity for a broader category of other official acts.
The air with breaking news from the Supreme Court, where the justices have just ruled on whether former President Donald Trump has absolute or qualified immunity for conduct involving his official acts during his time in the presidencies. The former president and his defense team made the argument that a president, not only former President Trump, but any president, has absolute immunity, this after he was criminally charged with plotting to overturn the results of the 2020 election. The import of this case simply cannot be overstated. How the justices' rule could well define the parameters of power of the American presidency and have something to say about the future of our very democracies.
The only conduct that remains clearly, unambiguously prosecutable is that which falls entirely outside the sphere of the presidency, purely private, non-official conduct. That is the law of the land. That is the new constitutional baseline. Legal analysts at outlets like WY and across the legal blogosphere immediately sounded the alarm, warning that this kind of broad, almost regal immunity can only serve to embolden a figure like Trump.
Attorneys representing former President Donald Trump argued to the U.S. Supreme Court Thursday that all presidents should have total immunity from criminal prosecution. We're joined now by one of those attorneys, Will Scharf. He's also a Republican candidate for Attorney General in Missouri, and he was in the highest court today. Good to see you, sir. Thank you for being here after a busy day.
Great to be with you.
It is the belief of your team that any president should have total immunity for official acts.
For official acts in office, and that's a very important distinction, as you know. Nobody here is arguing that presidents should have absolute immunity for their private conduct, but for official acts, acts that fall within the outer perimeter of a president's responsibilities in office, we believe that a president should have immunity, that without that immunity, the presidency itself would be crippled, and that no future American president would be able to effectively discharge his duties while suffering under the specter of potential criminal prosecution in the future.
It actively invites his legal team to march into court and argue that virtually everything prosecutors have ever charged as a crime, pressuring the Department of Justice to act as a personal law firm, leaning on state election officials to find votes, using the bully pulpit of the presidency to summon a mob, were all official acts of the executive and therefore shielded from any courtroom scrutiny. According to a comprehensive analysis that has been circulating in publications like The New Republic, commentators have argued that the court has indeed sealed everyone's fate, but not in the way the viral headlines suggest. The court did not seal Trump's fate by guaranteeing that he will be led away in handcuffs. The court sealed the fate of accountability itself by making it far more likely that the federal cases against him will be delayed into oblivion, narrowed to the point of irrelevance, or even thrown out of court entirely. The game now is about running out the clock while he occupies the White House, letting the statutes of limitations and the attention spans of the public do the work that a jury trial never will. At the very same time, we must acknowledge that the lower federal courts have not simply rolled over and accepted this new reality without a fight. There has been a spirited, almost desperate judicial resistance from the circuit courts and district courts that are closest to the evidence. A panel of the D.C. Circuit Court of Appeals, in a ruling that now reads like a prophetic warning from a doomed civilization, wrote that accepting Trump's view of total executive immunity would collapse our system of separated powers by placing the president beyond the reach of all three branches of government. They wrote with striking clarity that a president cannot claim unbounded authority to commit crimes simply because he wears the seal of the office. That was the lower court speaking. That was the voice of the judiciary trying to hold the line. But in the hierarchy of American law, the D.C. Circuit is not the Supreme Court. The Supreme Court overruled them. The warning was heard, and then it was ignored. In parallel proceedings, we have seen judges in deportation battles and cases involving the Iran war powers' threats attempting to wield the one tool they have left: contempt. They have threatened to hold Trump administration officials in contempt for defying court orders. But even in that context, the BBC's reporting is careful to note the cold, hard reality of the immunity framework. It is highly improbable that Donald Trump himself would ever face criminal charges for those specific acts of defiance. Why? Because the Supreme Court's immunity ruling acts as a force field. The officials might take the heat, but the man at the top remains shielded. This creates the perfect intellectual and rhetorical framework for the headline you see before you. You can absolutely frame this narrative as the clash between hope and law. Anti-Trump commentators and creators, driven by a genuine belief in accountability, declare that arrest is inevitable. They are expressing a moral and political yearning, but the actual Supreme Court, the institution with the final say over what the Constitution means, has made it exponentially easier for Donald Trump to argue that many of the most dangerous, destabilizing, and potentially criminal things he did while in office can never, ever be punished in a criminal court. The juries can still nail him for the personal grift, the hush money schemes that predate his oath of office. And the lower courts will continue to rage against his overreach, penning scathing opinions that will fill the history books. But as long as the Supreme Court keeps expanding the boundaries of immunity and narrowing the avenues for accountability, the phrase sealed fate looks less like a promise of a jail cell and more like a warning about the terminal condition of the constitutional system itself. So let's slow down and dissect the exact mechanics of what the Supreme Court immunity ruling actually accomplishes, because the devil is not in the details. The devil is the entire blueprint. The fundamental bedrock issue is that the Supreme Court granted Donald Trump a form of legal protection that the founders explicitly rejected when they threw off the yoke of the British monarchy. Immunity for official acts. Let those words sink in. Immunity means you cannot be prosecuted. It does not mean you get a fair trial. It means there is no trial. Official acts are the things a president does by virtue of being president. And here is the trapdoor that Trump's lawyers have gleefully swung open. Donald Trump can now argue with the Supreme Court's blessing that almost everything he did, from the moment he woke up in the White House residence to the moment he tweeted at 3 a.m, was an official act. This framework does not just protect Trump, It actively shields him from the consequences of his own design. The ruling establishes two distinct layers of protection. First, absolute immunity for core official acts. This is the nuclear-grade shielding. Core means the central constitutionally assigned duties of the presidency. The Supreme Court said that for these acts, the president is absolutely immune. No prosecution is possible. No investigation is even allowed to probe into the motives behind the act. This category is completely untouchable. It is a black box that no prosecutor is allowed to open. Second, presumptive immunity for other official acts. This creates an extraordinarily high bar for any prosecutor brave enough to try. Presumptive means the law assumes the president is immune unless the prosecution can prove, convincingly, that they shouldn't be. The burden of proof is flipped. It is not on Trump to prove he is innocent. It is on the government to prove that his official act somehow falls outside the scope of immunity. This is a steep, slippery, and often impossible legal climb. The only category that remains clearly prosecutable is non-official, private conduct. But what counts as private when you are the President of the United States? Personal business dealings? Perhaps. But most of the conduct that forms the backbone of the serious felony charges against Trump occurred while he was serving as president and ostensibly exercising the powers of that office. Therefore, under the logic of Trump versus United States, those acts are likely official and therefore likely immune. The prosecutable category is minuscule. It is a pinhole where prosecutors need a wide-open door. Trump's legal team is now using this ruling as both a shield and a sword. They are arguing that pressuring the Department of Justice to investigate bogus claims of election fraud was an official act. And why wouldn't it be? The DOJ is part of the executive branch. The president is the head of the executive branch. Under the unitary executive theory that conservatives have been pushing for decades, the president has absolute authority to direct the DOJ. Therefore, demanding that the Attorney General declare an election corrupt or just say it was corrupt and leave the rest to me and the Republican congressman is now being reframed not as obstruction of justice, but as an official executive function. If the Supreme Court's logic holds, this means the act of weaponizing the justice system for personal political gain is officially immune from prosecution. They are also arguing that leaning on state officials, like the now infamous phone call to Georgia Secretary of State Brad Raffensperger, asking him to find precisely 11,780 votes, was an official act. The defense is that the president was managing federal-state relations. He was concerned about election integrity. He was executing his duty to take care that the laws be faithfully executed. This reframes an attempt to overturn a certified state election result as a routine federal oversight duty. And they are arguing that using the bully pulpit, specifically the speech on the ellipse on January 6th, was an official act. The president was addressing the nation on a matter of public concern. The speech was given from the White House grounds using the trappings of the office. If that speech incited a mob to storm the Capitol, the argument goes, the act of speaking was still official. And if the act was official, the president is presumptively immune from any criminal consequence for the violence that followed. This is why outlets like the New Republic have framed this as the court sealing everyone's fate. They recognize that the impact of this ruling extends far beyond the personal legal jeopardy of Donald Trump. This ruling applies to every future president, from Kamala Harris to J.D. Vance to whoever follows. The court has sealed democracy itself into a fate where the executive can operate in a zone of criminal impunity. The practical effect on the federal cases is exactly as analysts predicted. The cases are likely to be delayed because every single charge now requires satellite litigation to determine whether the act was official or private. They are likely to be narrowed because prosecutors, recognizing the futility of fighting the immunity wall, will drop the charges that touch on core executive functions. And they could be thrown out entirely if a judge determines that the entire course of conduct was within the outer perimeter of the president's official duties, and the clock is ticking. Running out the clock while Trump is in office is the ultimate defense strategy. Justice delayed is not just justice denied, it is justice murdered and buried. Trump's term runs until early 2029. If his legal team can keep these cases tied up in procedural knots over the definition of official act for the next few years, Trump will leave office on his own terms. By the time any case might realistically proceed to trial, he will be well into his 80s. The political will to prosecute an elderly ex-president will have evaporated. The witnesses will have scattered. The evidence will have grown cold. Time is Trump's most loyal ally. The lower courts, to their credit, tried to stop this. They rejected Trump's most extreme claims of total immunity. The D.C. Circuit's warning that accepting Trump's view would collapse our system of separated powers was a precise, accurate forecast of the storm that was coming. They understood that if a president cannot be held accountable by the courts, then the courts are no longer a check on the executive. They are merely an advisory body that the president can ignore. They said clearly that a president cannot claim unbounded authority to commit crimes. But the Supreme Court disagreed. The Supreme Court looked at that warning and said, actually, he can claim that authority, and we're going to let him. The lower court resistance was valiant, but it was ultimately overruled by the institution that matters most. In the American judicial system, the Supreme Court has the final word, and that final word was a gift to executive power. Even when judges in the lower courts try to enforce the law through contempt proceedings against officials who defy orders on immigration or war powers, the immunity framework looms over everything. The BBC's analysis is crucial here. It notes that even when officials are in the crosshairs for contempt, it is highly improbable that Trump himself will face charges. The immunity ruling acts as a personal shield. The subordinates might take the fall, but the king remains on the throne. This is the clash between hope and law made manifest. The hope is that the system will work, that a judge will get angry enough to order an arrest, that the marshals will walk into the West Wing, but the law, as currently interpreted by the highest court, says the president is protected from exactly that kind of accountability. The anti-Trump creators who declare arrest inevitable are speaking from the heart. They are expressing a deeply held political desire. But inevitable is a word that implies certainty, and in the legal world, the only certainty the Supreme Court has provided is that prosecuting a president is now harder than it has ever been in American history. Let's dig much deeper into the consequences of this ruling, because this is where the rubber meets the road in terms of what kind of country we are becoming. Trump now operates without any functional fear of criminal accountability during his second term. The deterrent effect of the law has been surgically removed. He knows he has immunity. He knows the cases are stalled. He knows that even if he pushes the envelope further, and he will, the courts have given him a legal argument that he is just doing his job. This emboldens him. It frees him from the constraints that previous presidents felt, even if those constraints were often self-imposed. He can commit violations openly because the Supreme Court has told him, in essence, that he is above the law for a vast swath of his official conduct. And perhaps more terrifying, future presidents will inherit this immunity. This is not a one-off ruling for a unique character. This is a structural change to the office of the presidency. A future Democratic president or a future Republican president will wake up every morning knowing that they possess this absolute shield. They will know that they can pressure the DOJ, pressure state officials, and use the military in ways that blur the lines of legality. And as long as they can articulate a colorable argument that they were acting in their official capacity, they will never see the inside of a jail cell. This creates a permanent accountability crisis. It is a fundamental alteration of American democracy. Prosecutors will abandon cases they know they cannot win. The Justice Department is staffed by career lawyers who are risk-averse and who understand the new legal landscape. When they look at a case against a former president, they will see the immunity wall. They will know that they have to overcome the presumption of immunity. They will know that the litigation will take years and cost millions. Many will simply decide that the juice is not worth the squeeze. Charges will be dropped. Investigations will be closed. A justice gap will open up where presidential crimes simply go unaddressed because the legal system has admitted defeat in advance. The public will lose whatever remaining faith it had in the concept of equal justice under law. We already live in a country where the average person feels that there is one set of rules for the powerful and another set for everyone else. This ruling confirms that suspicion beyond any reasonable doubt. A regular person who pressures a government official to change a vote count goes to prison for a very long time. A president who does the same thing gets a legal presumption that he was just doing his job. The two-tier justice system is no longer a conspiracy theory. It is the explicit written doctrine of the United States Supreme Court. Presidential power expands into a vacuum where no criminal check exists. The founders created a system of checks and balances. Congress checks the president. The courts check the president. Elections check the president. Criminal prosecution was supposed to be the ultimate check, the backstop for when all other checks failed and the president engaged in high crimes. That backstop has now been removed for a massive category of presidential behavior. The presidency is now, in a very real legal sense, less constrained than it was before 2024. Congress becomes the sole remaining mechanism for accountability, but Congress is structurally inadequate for the task. Impeachment is the remedy. But as we have seen repeatedly, impeachment is a political process, not a legal one. A partisan Senate will simply refuse to convict, regardless of the evidence. The founders never intended impeachment to be the only check on a criminal president. They assumed the criminal law would apply once the president left office. The Supreme Court has now narrowed that assumption to the point of near invisibility. Trump's subordinates will continue to face prosecution while Trump himself escapes. This creates a profound loyalty crisis within the executive branch. Why would any official stick their neck out and follow a legally dubious order from the president when they know they will be the one left holding the bag in criminal court while the president claims immunity? The incentive structure is perverse. It discourages officials from carrying out the president's agenda, but it does so in a way that highlights the fundamental injustice of the system. The pawns go to jail. The king stays free. International observers watch this unfold and see the American model of democracy failing in real time. For decades, the United States has lectured the world about the rule of law, about independent judiciaries, about the importance of holding leaders accountable. Now, the world watches as the American Supreme Court grants its president a form of legal immunity that is more commonly associated with authoritarian regimes and absolute monarchies. America's soft power, its moral authority, bleeds out onto the floor of the courtroom. Trump will use this immunity ruling as a justification for increasingly extreme actions. He will point to the Supreme Court opinion and say, "The court says I can do this. The court says I am immune." The ruling becomes not just a shield, but a permission slip. It becomes a license to push the boundaries of executive power even further, knowing that the courts have already signaled they will not stand in the way. The legitimacy of the Supreme Court itself suffers a grievous, perhaps fatal, wound. The public sees a conservative majority, 3 of whom were appointed by the very man they are now protecting. The public sees a decision that aligns perfectly with the political interests of the Republican Party. The appearance of neutrality, the precious fiction that the court is above politics, is shattered. The court is seen as a partisan actor protecting its own patron. And once that perception takes root, the court's ability to function as the final arbiter of the law is permanently compromised. So, what happens when the Supreme Court gives a president this kind of broad immunity, making prosecution nearly impossible? The consequences cascade through the system like a wrecking ball. Trump operates without fear. Future presidents inherit the same armor. Prosecutors abandon the field. The public loses faith. Presidential power swells unchecked. Congress proves incapable of filling the void. Subordinates take the fall. The world watches democracy stumble. Trump uses the ruling as fuel for further overreach, and the Supreme Court's own legitimacy crumbles under the weight of its partisan alignment. The bottom line is this: the Supreme Court has not sealed Trump's fate for arrest. This landmark immunity ruling has made it harder and slower to prosecute him by carving out broad protection for his official acts. What is real is a growing split screen. Lower courts and juries say he can be held accountable. SCOTUS hands him tools to delay and dodge. Inevitable arrest is more political battle cry than legal certainty. The court's holding gives absolute immunity for core acts and presumptive immunity for other official acts, leaving only private conduct clearly prosecutable. This broad immunity emboldens Trump. It invites his lawyers to argue that pressuring the DOJ, leaning on state officials, and using the bully pulpit were all official acts shielded from prosecution. The court has sealed everyone's fate by making it likely that federal cases will be delayed, narrowed, or thrown out entirely, running out the clock while he remains in power. Lower courts have rejected total immunity claims, warning that such a view collapses the separation of powers. But the Supreme Court overruled them. The clash between hope and law is real. The anti-Trump world says arrest is inevitable, but the actual Supreme Court has made it easier for Trump to argue that the most dangerous things he did can never be punished. Juries can convict for personal crimes. Lower courts can rage. But as long as SCOTUS expands immunity and narrows accountability, sealed fate is a warning about the system, not a promise of a jail cell. The court hasn't guaranteed Trump's arrest. It has handed him a shield that keeps most official act cases from ever reaching a verdict. Trump walks without fear. Future presidents inherit the shield. Prosecutors drop cases. The public stops believing in equal justice. Power expands. Congress fails. The world watches. Trump escalates. And the court's own reputation burns.